All right, so I want to welcome you, Jeffrey and Catherine,
Good
and
morning.
we're here to talk about DC compliance issues. And what we have on board with us are, one of the challenges I have about DC is that DC doesn't publish the real estate commission activities and the disciplinary actions. So I have to go to other jurisdictions to look for material to put for the Washington, D.C. cases. So that's part of my problem with trying to research and coming up with material for Washington, D.C. Even though the Real Estate Commission says we have to do it, they don't really help us with trying to get materials to do it. So I have to be creative. So for that reason, I am using material today from the Maryland Real Estate Commission, which has applications for our for us today in Washington, D.C. So I want to welcome you and excited to have everybody on board with us. So this case involves Amanda Powell versus the Real Estate Commission on a Maryland case that has relevancy in Washington, D.C. So the case overview, the Real Estate Commission received a complaint from Elizabeth Ridgely against Amanda Powell regarding a residential property transaction in Maryland. The allegations were that Amanda Powell, acting as the buyer's agent, allegedly failed to ensure agreed upon repairs were completed before the settlement and did not advise the buyer of options such as postponing settlement or requiring an escrow deposit for incomplete repairs. The violation, Powell's actions were alleged to violate Com Air 911202A, which mandates agents to protect and promote their clients' interests. Also, not mentioned in the complaint is the fact that there are duties that we owe in the Code of Ethics. But the Real Estate Commission doesn't really focus on the Code of Ethics. They just focus on what's required in the law. So the resolution, Amanda Powell agreed to voluntarily surrender her real estate license and committed to never seeking a reinstatement in Maryland. The consent agreement between the parties, Powell waived her rights to a hearing, findings of fact, further proceedings and appeals, and the agreement is not an admission of guilt, but a compromise to avoid further administrative and judicial processes. So the final order issued by the Real Estate Commission was that the commission accepted her agreement to surrender her license and never to seek reinstatement. So the key dates, this started all in 2020, and it was finally settled in August of last year. So the lessons to learn here, it's the importance of when negotiating a resolution to a home inspection contingency, a licensee has specific obligations to their client. The importance of a clear written agreement is the biggest key issue. So when you're negotiating that home inspection contingency and you're coming up with a resolution, it's critically important to have really clear and unambiguous language to describe what it is that the buyer is expecting the seller to do. So vague sentences like the seller to fix roofing shingles, that's a vague statement, and it's unclear about what that really means. So that's not a good way to articulate it. A better way to articulate it might be seller to fix damaged roofing shingles described and shown in the report page, whatever, and photos, whatever, using an exact matching roofing shingle material and color as the remaining roof, and providing an actual specified product number if you can, that would match it. That would be an ideal way to articulate that kind of language to all the parties, so that it's clear, concise, and there's no question about what's really being asked for. Another example might be that the buyer requests seller to fix blank, 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 whatever. This implies a very non-specific request rather than a specific requirement. A better way to articulate that would be to say parties agree to fix the cracked foundation wall. Be very specific about what it is that's described on page X, photos XYZ in the home inspection report, according to the specifications in the engineering report. So, you know, you know, that this would assume that you're going to go to, you're going to see the crack in this foundation. The inspector is probably going to recommend to you an engineering inspection to determine, to make sure that that's not going to be a crack that is of structural importance, and probably recommend to you to get a waterproofing specialist in there to fix it. So you're going to describe the engineering report requirements, what the engineer has reported. You're probably also going to specify in the paragraphs that exactly what it is that the engineer or the inspector had requested. All work must be performed by a certified, registered, licensed XXX contractor. Now, use XXX contractors specifically because a lot of people simply go up and particularly in the District of Columbia, there are two types of licenses that we need to be aware of. There's a business license, which any business doing business in DC has to do. But on top of that, there's a type of home improvement contractor license. And when we're talking about home inspection repairs and licensed, being a licensed contractor, the licensed contractor is not talking about the business license. I mean, that's going to be required anyways, but what this contingency talks about is the specific type of home improvement contractor that's needed for that specific kind of job. Now, that might be a general contractor, but just understand that a general contractor can cover everything. And they would be required to then hire subcontractors underneath them to warrant any work that gets done. So make sure that we're not, when you're looking up the licensee status of a contractor, and this applies to Maryland and Virginia as well. When you're looking up whether a contractor is licensed, it's fine to look up to see if they have a business license, but it's much more important to see that they have a specific kind of general contractor license, or they're an electrician, or they're a plumber, or they're just a handyman type thing. And each of the jurisdictions has their own definition for these terms. So you need to look and see and apply the standard of what kind of specialists we're talking about for the specific kind of fault that was found in the home inspection. So parties agree to fix the cracked foundation wall described by the engineering report, specific paragraphs, specific pictures. If a general contractor is going to be satisfactory, then state that. If a specialty contractor is needed, then state that. Note that the licensing in most jurisdictions has two components. Again, we just talked about that. The building code home renovation contractor license is really the one that we're really talking about for this purpose. The District of Columbia wants to see that business license so they can collect the revenue. But in order to comply with this paragraph, we're talking about the type of home improvement contractor license. That's the kind of contract, that's the kind of licensee that we're talking about. So verifying that the repairs were completed directly, that's the second requirement that we have here. So it's our duty as buyer's agents to make sure that we verify that those are done correctly, at least to the best of our ability to interpret. And apparently in this particular case, in this case file that we're talking about, this agent didn't do that. There was a punch list of things that needed to get done. She didn't verify whether it got done. They just went to settlement and just closed on it, and the buyer was left holding the bag for everything. So to ensure the repairs were completed according to the agreement, a licensee should ensure that the wording of the resolution agreement addresses all the identified issues very clearly and specifically. Be very, very explicit, because if you leave any ambiguity in that agreement, you're going to get ambiguous results, and ambiguous results lead to disputes, and disputes lead to litigation, et cetera, et cetera. So advise the client to consult with the original inspector or specialized expert to certify that the work was done to the required standards. Don't be afraid to get that inspector back out there, or that engineer, or whatever that, to verify that stuff, because if we are not qualified as licensed agents to identify what the material issues are, then we have to rely on the home inspector to do that. If you are assuming that liability yourself, that's a precarious position that you could be putting yourself in. and that's probably not healthy either. So in handling these unsatisfactory repairs, if corrective repairs are not materially satisfactory, the licensee should advise the buyer of their options. And again, in this particular case, this agent didn't do that. The buyer's agent didn't tell the buyer what their options. First of all, they didn't verify that the repairs were done. Secondly, they didn't talk about what their options were in the event that the items were not done. So delaying settlement is always one option. Consider delaying the closing until the repairs are completed to a satisfactory standard. Consider using an escrow holdback to negotiate a substantial escrow of funds from the seller's proceeds to ensure the work can be completed after closing. That's one possible solution. Accepting the defect and having the buyer understand that if they accept the defect in the repairs that were not completed, they have a right to just accept it and not challenge the seller on it and just close the deal, so long as they understand that they're just accepting it and they're going to fix that stuff themselves. Or seeking or seeking other solutions. So explore other negotiated solutions. My observation on this case is that I'm surprised that the agent just simply gave up. They didn't defend themselves in the hearing. They didn't even appear in the hearing. They just gave up and said, "Here's my license, I quit." And that was their solution. So, if they had defended themselves in the hearing, they probably would have. The mistakes that were made were not so egregious as to warrant losing her license, but she defaulted to losing her license because she didn't participate in her defense, and that's the position that she took, and she just went along with it, and that's the way that it went. So that's my take on it. Does anybody have thoughts or considerations or questions on what we've just talked about? Nobody?
Then, in the event that the work isn't done, there's always a challenge to get the other party to understand what needs to get done. Right?
Yeah.
And most lenders will not allow escrow.
We're seeing more escrows now.
We are.
Yeah, we are seeing more escrows happening for these kinds of things now. We're seeing that a lot of times that is true. The majority of times I would say that you're right, Shafiq, but I am seeing some transactions come through with those kinds of escrows. But yeah, go ahead, continue on with your point.
As clear as you are in that list of things to do, it's just really hard when you're at closing to get somebody to get moving on doing it.
Yep. You're right. It absolutely is hard. I'm not saying that any of that is easy, but I am saying that is what our obligations are to our clients. Now, ultimately, I think in this particular case, if the agent had done these things and at least made efforts to try towards getting these things done, then she probably would have been not liable for anything anyhow. And it would have all fallen on the buyer's responsibility to resolve it, assuming that she had done all of her duties, and at least that she had attempted to make the effort to protect the buyer. But in this case, she didn't do anything, and she just quit.
Should we tell a client that they should not close until it's resolved, or should we be telling them to seek counsel?
Yeah. That seeking counsel would be the key there. As a general rule, if it's a very minor issue that a judge might consider as not being materially significant, I would not want to use that kind of leverage to say we're not going to settle until you put the screw in that light fixture, or something silly like that, right? On the other hand, if it is something that is materially significant and might potentially cause a buyer not to want to buy the property because it was so serious, then that's something that they probably would want to go ahead and talk to counsel, talk to brokers, vet the conversation out more deeply, and then consider not settling until it's resolved. That's one option, yes. Yeah. I would say when in doubt, talk to legal counsel. Absolutely.
And it's Kathy. Good morning, everybody. Just to go on Shafiq's point, I think that Dan already knows about a case I just had. Now, while it was in Virginia. I'm just going, not without going into it, due to the fact that escrow could not be held, as Shafiq is mentioning here, it can be a problem. The resolution there, this was over a roof, so this particular example was giving me a little PTSD over it. But what happened, the solution was at the settlement, or well, the morning of settlement, was that there had been a bill produced from a roofer that provided an estimate on the work that was in dispute. So instead of the title company holding an escrow, what they did is they took proceeds from the seller, physically had a check that was made out to that roofer for the repairs, held that check till everything was done, because we had actually given a credit for the repairs to be done on the settlement sheet, but the problem was the buyer was nervous that it would be done correctly. So they wanted an additional security blanket. So the title company held funds in the form of a check from the title company to the roofer as assurances the work would be done correctly. Once the work was done correctly, then, and it was under the original agreement where we credited them, then the title company just sent that check in a voided form back to my sellers. So that was a way to get around the fact that the lender did not have to approve an escrow for a roof repair. So that's just another example of maybe a way that could be a workaround so you could get to settlement on time, satisfied the buyer, satisfied my seller, and all was well because my seller did get that entire amount returned to them.
Yeah, and don't be afraid of doing that. Don't be afraid of getting the title attorney involved. Because they don't want to see, or they don't want to see a deal fall apart. They don't want to hold earnest money deposits indefinitely. So it's in their interest to get these issues resolved as quickly as they can. And any good title attorney worth their salt is going to work to try to do what they can to have creative solutions like that, to make the deal work out. And if your title company doesn't have an attorney on staff, that might be something to consider. Something, and so if they're not able to provide those kinds of solutions like that, then that's worthwhile. So anybody else have any thoughts or questions, comments, or whatever? Thanks, everybody. And thanks for coming in today, and have a great, powerful day. And we'll see you in, if anybody's going to Leesburg today for the business session, we'll be there in Leesburg. And then on Tuesday, I think we're going to be in Falls Church. So hopefully we see you there. Thanks, everybody. Take care. Bye.
Dan, bye.
Thank you.